Are you planning a party and are you worried about the legal risks that may be created by intoxicated guests? I'm Sam Clark from Brownlee LLP in Calgary, Alberta, and I'm going to speak to you today about social host liability in Canada and what steps a responsible host can take to limit the harms caused by intoxicated guests. People like to gather and celebrate the important milestones in somebody's life, whether that be a birthday, a wedding, or an anniversary. Oftentimes, these celebrations are held at someone's house, cottage, or cabin. Frequently, these celebrations involve the consumption of alcohol. Sadly, all too often, an intoxicated person will leave the party and either injure themselves or injure other people. Sometimes the host is sued by the injured person. The question then becomes, can the host be held liable for those injuries because they hosted the party where alcohol was consumed? A recent case from British Columbia, McCormick v. Planbeck, shows that Canadian courts treat the host of a party where guests consumed alcohol when that guest injures themselves after leaving the party. Historically, Canadian courts have been reluctant to deem a host liable for the actions of an intoxicated guest. The Supreme Court of Canada in Childs v. Desenroe held that a social host who allows guests to consume alcohol usually does not owe a duty of care to people who are injured by the actions of an impaired guest. However, the Supreme Court of Canada did outline two exceptions to that rule for social hosts. The first is when a host intentionally creates a risky situation, such as inviting guests to engage in risky activities. Hosting a private party where guests consume alcohol was deemed not to be an inherently risky activity. The second situation is when there is a relationship of supervision of control, similar to that between a parent and a child, between the hosts and their guests. Since Childs, Canadian courts have been reluctant to classify a social host into either of those two categories. McCormick is the first trial decision post-Childs where a Canadian court has found sufficient proximity between the hosts and their intoxicated guests. In McCormick, Lydia and Stephen Pearson allowed their 16-year-old daughter, Hannah, to host a party at their house as long as guests did not drink and drive. Guests could consume alcohol at the party, but the Pearsons did not provide alcohol at the party. The Pearsons patrolled the party every hour, required that the party end at 1 a.m., took the keys from guests as they arrived at the party, and told guests to call their parents if they needed a ride home, and drove home any guests who did not have a ride home. One guest was Calder McCormick. He was an 18-year-old who came to the party with his friend Ryan Planbeck. At the party, Calder and Ryan consumed alcohol and cannabis, but not enough to be visibly intoxicated. After the party ended, Calder and Ryan left the party on foot. Ryan knew a neighbor who was trying to sell a car and that he left the keys for the car under its handbrake. Calder and Ryan stole the car, took it for a joyride, where Ryan crashed the car, killing himself and seriously injuring Calder. Calder then sued the Pearsons, claiming they owed him a duty of care as hosts of a party where minors consumed alcohol and cannabis. As part of the duty of care, the Pearsons had a duty to protect their partygoers from injuring themselves or other people. The Supreme Court of British Columbia found that the Pearsons did not owe a duty of care to Calder because it was not foreseeable that he would injure himself or other people when he left the party because he was not visibly intoxicated when he left the party. However, the relationship between Pearsons and Calder was deemed to be a paternalistic relationship of supervision and control. This was because the Pearsons allowed minors to consume alcohol and cannabis at their house, that they could prohibit guests from attending the party, that they could control the activities of their guests, and they could limit excessive drinking. Even if there was a duty of care, the Supreme Court of British Columbia found that the Pearsons met the standard of care for a social host. The standard was to take all reasonable actions to minimize harm rather than a standard of perfection. The Pearsons met this standard because they took the keys of guests as they arrived at the party, they offered guests a ride home if they could not have a ride home, they told guests to call their parents if they needed a ride home, and conducted hourly patrols at a party. The standard was not higher because the majority of guests were minors, such as the standard that would be held by a bar or other licensed establishment. The McCormick decision likely makes it easier for someone injured by an intoxicated guest from a party to sue the host of that party. It will likely be difficult to obtain summary judgment in a situation where the impaired guest was a minor because of the paternalistic relationship established in McCormick. McCormick also shows a duty of care can exist between a host and their guests if the guests are minors, or if the host creates or exacerbates a risk, even if the host does not serve alcohol. However, social host cases are all very fact-specific, and the outcome of any such case could vary significantly depending on the facts of the case. The McCormick decision also provides some clarity for hosts. For an injury to be foreseeable, whether the guest is a minor or an adult, the guest would have to be visibly intoxicated when they left the host premises. This is a higher standard than merely consuming alcohol at the premises. Calder's injuries were not considered foreseeable because he was not visibly intoxicated when he left the Pearson's residence. This decision also provides guidance for what hosts of a party can do to limit their exposure to the actions of a guest who consumed alcohol at their party. Hosts can take many steps to limit their exposure to liability. First, they can create a plan to ensure guests will not be driving home. This could include taking their keys, encouraging guests to call a parent or a friend to give them a ride home, giving rides home to guests who do not have a ride home, or allowing guests who have consumed too much alcohol to stay at their residence overnight. Secondly, have someone that is sober monitor the guests for signs of intoxication. Third, provide food and non-alcoholic beverages to guests at your party. Fourth, stop serving guests alcohol for a period before the party ends. Fifth, turn away guests that are visibly intoxicated from your party when they arrive. There are things hosts can avoid to limit their potential liability. First, if you are serving guests alcohol, do not serve visibly intoxicated guests or guests that drove to the party. Second, do not encourage guests to engage in activities that encourage alcohol consumption, such as drinking games. Third, do not encourage guests to combine alcohol with other intoxicating substances such as drugs. Fourth, do not allow minor guests to consume alcohol, especially younger minors. I hope this video was very helpful in helping you plan for your next party. If you have any additional inquiries, please feel free to email me at sclark@brownleelaw.com.